Hello everyone, welcome to Drishti IAS. You're watching the NCERT Foundation Series and today we are going to be covering the topic of Judiciary, wherein we'll be covering a few concepts of Judiciary, primarily focusing on the Supreme Court. So without further ado, let's plunge right in. The previous day question asked you, with reference to the composition of the Parliament, consider 1. President of India is an integral part of the Parliament. Now, this statement is in fact accurate. Article 79 of our Constitution actually says that there shall be a Parliament of the Union, that there shall be a Parliament of the Union which would have the President along with a Council of States as well as the House of the People. So, Council of States here means the Rajya Sabha and House of People means the Lok Sabha. So, even though the President is not a member of either of the two houses, he is still an integral part of our Parliament. Therefore, this statement is accurate. Statement 2 says Attorney General has the right to participate and vote in both houses. Now, before we go and discuss this particular statement, kindly tell me which article of the Constitution deals with or talks about the Attorney General of India. Now, Attorney General, of course, has that privilege. He has the right to participate in the proceedings of both the houses, which means the Lok Sabha as well as the Rajya Sabha. And not only this, the Attorney General can also participate in the joint sitting of both these houses. So this part is correct. However, he does not or she does not have the right to vote in those proceedings. So this part of the statement is wrong and therefore this statement, the second statement, may be eliminated. Your statement 3 says the Vice President is ex officio chairman of the Rajya Sabha. Now, ex officio actually means that by virtue of holding the position or by virtue of holding the office of the Vice President, he or she also becomes the chairman of the Rajya Sabha. All right? He or she may also become the chairman of the Rajya Sabha. He becomes the chairman of the Rajya Sabha simply by virtue of being the Vice President of India. Hence, the statement is correct. And with this, option A is our correct answer. All right. Now, the next question says, and this is a previous year's question asked in 2020. With reference to the Collegium system of appointments of judges, which of the following statements is correct? Now, before looking at the statement, let's first try and understand what exactly the Collegium system is. So, the Collegium system is basically a method or a mechanism for the appointment of judges of the Supreme Court. Now, this method or this system is not mentioned either in the Constitution, nor in any law of the Parliament. So, no such law has been passed by the Parliament, nor is it mentioned in the Constitution. Rather, it has evolved over time. It has evolved over time via 3 judgments of the Supreme Court. Now, what are those 3 judgments? Let's first try to understand what exactly the Constitution has to say about this system or the appointment of judges. Now, the first thing that the Constitution simply says that the Chief Justice of India will be appointed by the President, in consultation with any such judges of the Supreme Court or High Court that he may deem or she may deem necessary. That's all that is said. Now, by convention, what happens? By convention, the senior most judge of the Supreme Court is appointed as the Chief Justice of India. This is the convention, and this convention has been broken twice. Once in 1973, when A.N. Ray was appointed the Chief Justice by superseding three senior most judges, three judges that were more senior to him. They were superseded and A.N. Ray was appointed as the Chief Justice of India. And once again in 1977, this convention of appointing the senior most judges as the Chief Justice of India was violated or was broken. Please tell me in 1977 who was appointed as the Chief Justice of India superseding the senior most judge. Kindly let me know in the comments. Now, we talked about three judgments. So, since the Constitution does not explicitly tell about any mechanism or method for the appointment of judges, this method, the Collegium system, was gradually evolved by three judgments that led to this system. The first judge's case in 1981 talked about this word that was used here, and the word was consultation. Now, in consultation with such judges of the Supreme Court and the High Court as the President deems necessary, in the first judge's case, the Supreme Court interpreted consultation as non-binding. It said that when the Constitution says that there will be a consultation, it does not mean concurrence. It simply means exchange of views. It simply means exchange of views. Then what happened? In the second judge's case, of 1993, the Supreme Court overturned its own decision and said that the proper interpretation of the word consultation actually means concurrence. It means that the decision of the judges is going to be binding. And this judgment said that the President will consult the Chief Justice of India along with two senior most judges. Now again there was a third judge's case, and here it was reiterated that consultation actually means concurrence, and that the decision of this collegium or the decision of the judges is going to be binding. All right. So again, it was decided that this will be binding on the President. It was also decided that the decision of the judges will not be arbitrary but will be done with the CJI in consultation again with 4 senior judges of the Supreme Court. All right. Now this deals with the appointment of judges. So the Chief Justice of Supreme Court is appointed by the President, and the other judges of the Supreme Court are appointed by the President in consultation with the Chief Justice along with 4 other senior judges of the Supreme Court. All right. So this is the story. Now the decision therefore becomes binding on the president. So with this information, let's go back. It was established by a judgment of the Supreme Court. The Collegium system, yes, this is correct, because it was evolved by judicial interpretation rather than being mentioned explicitly in the Constitution. Therefore, this is correct. The recommendations of the Collegium are binding on the president. We've just discussed it. This is also correct, and therefore option C is our correct answer. Now, consider the following statements. Another PYQ asked in 2018. First, the Chief Justice of India is appointed by the President in consultation with the senior most judges of the Supreme Court. This is inaccurate because we just read that it is simply mentioned that the President will appoint the Chief Justice of India in consultation with such judges of the Supreme Court and the High Court as he may deem necessary. All right. So it is not mentioned. It is not mentioned that they are going to be the senior most judges of the Supreme Court. Statement 2 says the judges of the Supreme Court hold office till they attain the age of 65 years. This is in fact correct. The Supreme Court judges actually hold office till the age of 65 years, and their removal process or their impeachment process, if the Parliament wishes to remove these judges before they attain their retirement age, it is a very tedious, very difficult procedure, and we'll see why and how. So now only 2 is correct. Therefore, option B is our correct answer. Which of the following is not a safeguard of judicial independence? So in the preceding question, we were discussing how the impeachment process or the removal process of judges, Supreme Court judges, has been made very difficult in the Constitution, and that was particularly to make sure of or to ensure judicial independence so that their autonomy remains intact and they're not influenced by petty politics, all right, and or by the legislature as well. So of course there are quite a few things that have been, or few provisions that have been made in order to ensure their independence. One of them being fixed tenure till retirement. So we discussed that they retire at the age of 65 years and their tenure is fixed and their removal process is really difficult. And again, this acts as the segue to the second point, which is a difficult removal procedure. This is also correct. Now, judicial salaries charged on consolidated fund. This is also absolutely correct. Charged on consolidated fund means they are non-votable. All right, they are not voted and they cannot be diminished. All right. Again, there are few more let's say provisions made to ensure judicial independence. For example, their conduct cannot be discussed in the Parliament. Their conduct cannot be discussed. They also have immunity for their personal actions. They also have the power to punish the contempt of court. All right. So all of these, let's say, provisions are there to ensure that the judiciary acts independently and autonomously and is not influenced or does not act in fear of either the legislative or the executive. Parliament approves judges' conduct annually. We just discussed that their conduct cannot be discussed in the Parliament. Hence, this is our correct answer. All right. This happens to be our correct answer, option D. So before we move forward, kindly please look at the NCERT online course offered by Drishti IAS. And the good thing is that if you visit any of our physical offline centers to get enrolled in the IAS Foundation Classroom course, your fee will be waived off. The fee equivalent to the NCERT online course will be waived off. For more information, kindly check the link in the description box or call 87501 87501. With reference to the removal of a Supreme Court judge in India, consider the following statements. Statement 1 says a judge can be removed only for proved misbehavior or incapacity. Now let's talk again about the removal of Supreme Court judges. This is also called impeachment, just as in the case of the president. Now, when we talk about the reasons or the grounds for impeachment or removal, there are only two grounds that have been provided. One of them is proved misbehavior, or the second is incapacity. All right. So here, this is what is mentioned. But there is an act called the Judges Inquiry Act. Judges Inquiry Act of 1968 that lays down or that regulates the process of removal of the judges of the Supreme Court. Now, what happens is, first of all, a motion has to be admitted into the House. A motion has to be initiated and admitted into either the Lok Sabha or the Rajya Sabha. Now, in order for this motion to hold some force, it should be signed by either 100 members of the Lok Sabha or 50 members of the Rajya Sabha. All right. This should be the first step, or this is the first step. And then it is sent to the Speaker or the Chairman for approval. Now, it is up to the Speaker of the Lok Sabha or the Chairman of the Rajya Sabha to admit the motion. He or she may or may not admit the motion. All right. This is the next step. What happens next? Then, of course, the Speaker or the Chairman are going to establish an inquiry committee, because this is a big deal. All right. We are not dealing with a matter of some petty or trivial importance here. We are dealing with matter of gigantic importance here, gigantic significance here. So, almost monumental, one would say. So what happens is, then the Speaker or the Chairman is going to establish or institute an inquiry committee. And this inquiry committee shall have 3 members. Which are those 3 members? Those 3 members are going to be the Chief Justice of India or any judge of the Supreme Court, the Chief Justice of a High Court, and a distinguished jurist. A distinguished jurist. Now, once this committee has established that there is indeed incapacity or misbehavior on the part of a judge, then of course this motion to impeach the judge may be initiated in the House and voting may be called upon. Once this motion is called and the voting begins, how is the judge impeached, or what is the requirement? So, the resolution or the motion for the impeachment has to be passed by a special majority. All right. Special majority means a total a majority of the total membership of the House plus two-thirds of members present and voting. So this is the voting mechanism. If the motion is passed, and this has to be passed in both houses. Imagine how difficult this is. If this is passed in both houses, then the president passes an order effectively removing the judge. Now, this is so difficult is proved by the fact that no judge has been impeached so far, and only one judge, Mr. V. Ramaswamy, was, indicted. He was actually found guilty of misbehavior, of misappropriating funds, and despite that, he could not be impeached simply because even though there was a majority of two-thirds members present and voting in the Lok Sabha, the Congress party abstained from voting and a majority of the total membership of the House could not be attained, and therefore the motion was defeated in the Lok Sabha. Alright, so with this background in mind, let's try and attempt this question. A judge can be removed only for proved misbehavior or incapacity. This is accurate, that these are the two grounds that have been provided. Statement 2 says the motion must be passed in each House of Parliament by a special majority. Again, accurate. And Statement 3 says the only removal motion ever initiated was against Justice V. Ramaswamy in 1991. This is in fact again accurate. However, this motion was defeated in Lok Sabha. Alright. So he could not be impeached. Therefore, all three statements are correct and option D is our correct answer. So with this, we have discussed a couple of topics, particularly the appointment of removal of judges of the Supreme Court. We are going to be discussing further few more topics related to the judiciary, including the various sorts of jurisdiction and of course about the high courts as well. And this for you is today's practice question. Kindly send me the answers in the comment section, and if you found today's session useful, please like, share and subscribe. Thanks for watching.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.